What's up? This is the College Investor Audio Show. Today we take a look at this article, Federal Judge Strikes Down Education Department's New PSLF Employer Rule. Sounds serious. We're going to dive in just a second. Just a quick reminder, anytime you hear us talking about a topic on the podcast, you know there's an article where you can dive deeper on our website. PDF files, resources, links, and everything you could possibly want to know about the topic right there inside the article at thecollegeinvestor.com. Also, like and follow, subscribe, and all the clicky buttons on social media. Just type in the words The College Investor. We'd love to connect with you. All right, so a federal judge has thrown out the Department of Education's controversial, everything's controversial, really, new public service loan forgiveness rule, ruling it unlawful one day before it was supposed to take effect, which was June 30th, a few days ago. In a 68-page, can they ever be brief decision issued, of course, on June 30th, the day before the deadline the whole thing was supposed to work. The U.S. District Judge out of Massachusetts held that the rule was contrary to law, exceeded the department's statutory authority, was, quote, arbitrary and capricious, and violated the First Amendment. That's a lot. His order vacated the rule entirely. There's another case in the District of Columbia that's also about this same exact rule, still waiting on a ruling as of this podcast. All right, so the news. The decision resolves two consolidated lawsuits, Commonwealth of Massachusetts versus Department of Education and National Council of Nonprofits versus McMahon. The challengers included 22 states, Washington, D.C., 5 cities and counties, 5 nonprofit employers, and 5 employee associations. More than 100 amici filed briefs against the rule. As the judge pointed out, quote, 0 amici appeared in support of the defendants, end quote. Kind of saying something. And here's why it matters. So, PSLF forgives the remaining federal student loan balance for borrowers who make 120 qualifying payments while working full-time for 10 years at a qualifying public service employer, such as government agencies and also 501c3 nonprofits. The rule the court struck down would have let the department disqualify employers based on a new substantial illegal purpose standard. Borrowers at affected employers could have lost progress toward forgiveness through no fault of their own. The court found the rule chilled protected activity at organizations serving immigrants, teaching diversity and inclusion content, and providing gender-affirming care. Here are the details. So the judge's central objection was that the rule tied PSLF eligibility to the administration's policy priorities rather than to settled law. So its definition of substantial illegal purpose reached beyond established criminal statutes. Like, we just can't really tell. For example, here, creating its own definition of trafficking untethered to federal criminal law and treating civil immigration violations as grounds for aiding and abetting liability. Let's dive a little deeper. Administrations change with elections. Criminal laws don't. That's what the judge wrote. The court held the rule was unconstitutionally vague and effectively compelled employers to affirm the administration's view that all diversity, equity, and inclusion practices are illegal, a belief not settled law. Yeah, it's a philosophy. Even if you agree with it wholeheartedly or not, it's not a law. That's what the judge is basically saying. That's why it's unconstitutional. It's not even that the judge disagrees. It's just, you can't do this, guys. So let's connect the dots real quick. The rule had drawn scrutiny for months, and we've been covering it. Earlier this year, the department attempted to add a perjury attestation to PSLF forms, and states pushed to block the employer rule before the July 1st effective date. They came in just in time, didn't they? As the College Investor previously reported, the change had also raised concerns that teachers, nurses, and other public service staff could quietly lose PSLF status depending on their employer. The ruling lands during an already turbulent stretch for borrowers. The SAVE plan has ended. The new Repayment Assistance Plan, or RAP, has already launched, reshaping PSLF's strategy for the year ahead. This is a trial court decision, so the Department of Education can appeal to the U.S. Court of Appeals for the First Circuit. For now, though, the rule is vacated nationwide, and it does not take effect. That's important to know. So borrowers pursuing PSLF should continue certifying employment and confirming their payment counts through their federal loan servicer. Business as usual right now, and we will, you better believe it, keep an eye on this for you if you're in this program. Please like and follow and subscribe so you can always stay up to date on all the social media channels. Just search for The College Investor and you'll find us. Dive in deeper to this article. You can read the brief, the 68-page report, all the decision, I should say, and everything else at thecollegeinvestor.com. Thanks so much for stopping by today, and we'll talk to you again real soon.